Employee and Labor Relations Common Law Doctrines. Common Law Doctrines. Common law is also known as judicial precedent, judge-made law, or case law. Why is common law called common law? The common law in England was established by judges appointed by the king and operating in courts the king had created. So it is not common in its origin. It is called common because it established one law, the common law, for the whole kingdom. Why is common law important? By requiring wrongdoers to pay compensation to those whom they intentionally or negligently injure, the common law performs an essential social and regulatory function, encouraging the adoption of reasonable safeguards to protect others. What is the difference between common law and civil law? While common law systems have laws created by legislators, it is up to judges to rely on previous courts' precedents to interpret those laws and apply them to individual cases. In a civil law system, a judge merely establishes the facts of a case and applies remedies found in the codified law. What is common law tradition? Common law is a body of unwritten laws based on legal precedents established by the courts. The U.S. common law system evolved from a British tradition that spread to North America during the 17th and 18th century colonial period. Common law doctrines are the result of legal decisions made by judges in cases adjudicated over a period of centuries. Several doctrines have implications for employment relationships, such as the concepts of employment at will, respondit superior, constructive discharge, defamation, and negligent hiring. Employment at will. At will means that an employer can terminate an employee at any time for any reason, except an illegal one, or for no reason without incurring legal liability. Likewise, an employee is free to leave a job at any time for any or no reason without adverse legal consequences. Respondit superior. Respondit superior in Latin means let the master answer. This is a doctrine that a party is responsible for acts of their agents. For example, in the United States, there are circumstances when an employer is liable for acts of employees performed within the course of their employment. Constructive discharge. In employment law, constructive dismissal, also called constructive discharge or constructive termination, occurs when an employee resigns as a result of the employer creating a hostile work environment. Since the resignation was not truly voluntary, it is, in effect, a termination. Defamation. Defamation occurs when an employer harms an employee by intentionally making a false statement about the employee. If the employee's manager provides a false reference that hurts the employee's chance of getting a job or damages the employee's reputation, the employee may sue for defamation. Negligent hiring. Negligent hiring is a legal claim made against an employer. The negligent hiring claim argues that the employer knew or should have known their history before hiring them. Basically, if you are not diligent about finding out a candidate's background, you could be responsible for their actions. Finally, a legal doctrine is a framework, set of rules, procedural steps, or tests, often established through precedent in the common law, through which judgment can be determined in a given legal case. Study hard and learn your craft. Bye for now. Join the 365 HR Certified Study Group on Facebook today. It's free.